The question raised in my presentation today is, if not juries, then what? The subject, although provocative, is not an indictment of the jury selection system. I enjoyed jury trials in my tenure as a trial judge for over 16 years. I raised the question because my experience over time caused me to make observations about the composition of juries. Was it just coincidence that my juries generally underrepresented visible minorities in society, caregivers, students, persons of modest means? In 2015, the Supreme Court of Canada defined jury representativeness in a criminal jury case involving a First Nations accused by the name of Coco Penace. The Supreme Court decided that the constitutional standard underpinning charter rights to a fair trial by judge and jury was largely procedural. The standard is met by a selection process that gives reasonable opportunity to serve on a jury from a randomly selected cross-section of the community. The caveat is that the process must not amount to a deliberate exclusion of certain groups or members of the community. Query: does a randomly selected group chosen from municipal property assessment rolls allow this? My anecdotal experience laid that in question. As you're aware, Ontario has since advanced changes to the Juries Act to allow juries to be assembled from OHIP records, but no consensus on the strength of this alternative has been achieved. In 2017 and 2018, with the blessing of the Canadian Judicial Council, I set out to test my own anecdotal experience by carrying out both qualitative and quantitative empirical analysis on jury selection during an 8-month study leave. The findings of my study leave report came to light after the February 2018 acquittal of a Saskatchewan farmer charged with the murder of Colton Boushie, who was a First Nations individual. Defense counsel in the Colton Boushie case is said to have used the criminal code peremptory challenges to purge the jury of First Nations individuals. The Boushie case laid bare the ongoing dissatisfaction of First Nations with the Ontario jury system. This was despite the fact that 5 years before that, the Ontario government had paid for and received the advice of former Supreme Court of Canada Justice Frank Iacobucci, who made pointed recommendations about needed changes in the jury selection process in Ontario. The majority of these recommendations have not been put in place. The Toronto Star, in conjunction with the Ryerson School of Journalism, carried out its own mini-study of over 600 jurors selected to serve on criminal juries in Toronto and Brampton, and it released its findings in February of 2018, just around the Colton Boushie trial. In that study, investigative journalists simply did a visual survey of the racial makeup of the jurors using police classifications of race based on visual appearance: white, Black, Indigenous, brown, Asian, or other, whatever that means. I'm sure you can all appreciate that these visual observations fall well short of any precise standard of empirical analysis. But more concerning is the fact that the Ryerson study did not apply the Coco Penace test put in place by the Supreme Court of Canada for jury representativeness. As I mentioned, That test looks at the process of assembly of the jury roll, not the composition of the jury after in-court selection, as the Ryerson Toronto Star study was based on. My study leave findings were made public by the Canadian Judicial Council in June of 2018, after Ottawa Council in a triple homicide compelled their release. My findings are available along with my data analysis on the Canadian Judicial Council website. My study applied the Coco-Penase test. With the help of a social geographer, we matched or geocoded the address of over 5,500 persons on jury panel lists for Ontario and Belleville for 2016 to information profiling residents within their identified census tracts based on the most recent census carried out in 2016. Our data analysis did not reveal the actual identity of persons on the jury rolls we studied, but produced nonetheless a near 100% accurate profile of the over 5,500 panel members based on trends they identified for the census tracts. The Ottawa geocoding study revealed that Ottawa jurors were predominantly populated by white, higher income property owners reporting English as their mother tongue. The geocoding study supports the need to adequately compensate jurors in order to allow low-income earners, renters, visible minorities, a reasonable opportunity to serve on juries. This was recommended in 2012 by the Provincial Jury Implementation Committee of the Superior Court of Justice for Ontario. This was reiterated in 2013 in the Yakabuchi report. Action has yet to be taken by the Ontario government in relation to compensation of jurors. One juror's advocate, Mark Ferrand, who founded the Canadian Juries Commission in 2019 to lobby for the interests of jurors, has warned that the impact of COVID-19 could leave Canadian courts with a severe shortage of jurors unless provinces provide improved support, starting with increasing juror compensation. In Ontario, jurors are not paid for the first 10 days of service. After that, they get an honorarium or allowance that doesn't even approach minimum wage. This has been the case for many, many years, a very long time, and certainly longer than my time on the Superior Court of Justice. The Belleville study was the second of my geocoding studies, and it was done in 2017, completed in 2018. It was done because Belleville is a court center in the East Region, where I served, that includes the Tyendinaga Mohawk Territory and First Nations Reserve. I wanted to see whether the pilot project to improve First Nations participation on juries, which was put in place after the release of the Yakabuchi report in 2013, had had any impact. I learned that not a single juror on any panel list for 2016 came from the reserve. That was a sobering discovery. The Belleville study also showed that the most represented census tracts on the jury roll tended to include fewer individuals from visible minorities, more high-income earners, and higher levels of property ownership. There's a strong argument to be made that geocoding jury panels objectively profiles whether a jury roll reflects the community from which it is drawn and whether the jury roll can generate juries, once elected, that are the conscience of the community. It's perhaps the most scientific way to test whether juries meet constitutional standards. It also tells us whether government programs or legislative changes address the procedural and systemic reasons for lack of participation of certain groups on juries. The Supreme Court of Canada in Coco Penace said that if government does not take corrective measures to address long-standing and well-known problems, this can amount to deliberate exclusion of groups on juries and breach charter rights to a fair trial by judge and jury. In advocating for the geocoding of jury panels, since the Ministry of the Attorney General for Ontario keeps no jury statistics, I am not suggesting that juries, once selected, would not comprehend or follow their instructions, regardless of their composition. But given the secrecy of jury deliberations, we just can't know for sure. I can say that there are limited studies on juror comprehension referred to in my study leave report that were done by PhD candidate Marie Komisky. Her analysis raised other questions I don't have time to get into today. I would also commend to you the decision of Justice Peter Daly, released in April of 2019 in Kapoor and Kuzmanovsky, which dismissed the plaintiff's challenge to the jury array. The challenge was based on impugned social science evidence that was offered to support the argument that members of the Brampton jury panel, who pay the highest auto insurance premiums in Ontario, could not be expected to be impartial if a significant award of damages in motor vehicle litigation could contribute to higher premiums. Will there be more such challenges to jury arrays? Could they be based on stronger and unimpeachable social science? If the answers are yes and yes, will the Ontario government's efforts to improve the system sustain scrutiny in the future? These are all important questions for the future of juries, including civil juries. Recent civil rules amendments in Ontario do away with juries in simplified rules cases for claims of $200,000 or less. These amendments will likely dispose of many civil jury cases based on awards we've seen in motor vehicle accident cases in recent years. Attorney General for Ontario Downey is now considering, in consultation with all stakeholders, whether civil juries in Ontario should continue to be allowed. This is not the first government to ask that question, and the question will not be answered anytime soon, I am sure. There's no doubt that since March of this pandemic year, with all jury trials, civil and criminal, put on hold, the debate about jury representativeness has been temporarily put on mute, while the courts have retooled for e-hearings. The courts are now looking to reintroduce criminal jury trials in the fall and jury trials in civil cases in 2021 at the earliest. And no doubt, the debate about jury representativeness will resume at some point after that. As a judge, I did not participate in the debate. I just examined the trends. Now that I'm beyond the confines of my judicial office, I still do not engage in the debate. I look beyond the courtroom and the jury trial. I work with parties and counsel to expand the ways they can improve litigation outcomes in a more timely way. This will be necessary, given other litigation realities counsel grapple with, quite apart from COVID-19 restrictions to access to justice. As an example, the current statutory accident benefits schedule that applies to motor vehicle accidents in Ontario leaves a gap in coverage given the more restrictive determination of catastrophic injury. If there are persisting delays in civil actions coming to trial, whether jury or non-jury, litigants need to consider other ways to move their cases to resolution. So that brings me to the second part of the subject of my presentation. If not juries, then what? In the course of doing an executive program on mediation at Harvard in Boston last year, I met certain published giants in dispute resolution, including Dana Curtis, Gary Friedman, and Robert Mnookin. Mnookin is the author of many books, but one in particular called Negotiating with the Devil, a book he wrote after he was engaged by the White House to negotiate with the Taliban after 9/11. The course instructors put me onto two dispute resolution tools I'm excited to use in my current role, over and above more classic forms of mediation and dispute resolution. They are co-mediation and early neutral evaluation. Co-mediation involves multiple mediators, usually two, whose professional skills are combined to enhance the quality of the mediation process as well as its outcome. Legal research and social science have shown that co-mediation can be done with little or no increase in the cost of the process and can even shorten the process. In the typical multi-party case, momentum can be lost and even regress as parties sit in separate rooms in dead time, waiting for a single mediator to shuttle back and forth in caucusing. In co-mediation, each mediator works with a party and shares information confidentially with the other mediator, building upon the knowledge base of both mediators in a collaborative progression towards settlement. Although there's more than one type of co-mediation, there is consensus that legal and industry experts work best together in multi-party cases involving catastrophic injury, wrongful death, professional liability, and insurance-related disputes. The legally trained expert brings to the table knowledge of the law, which is combined with that of the industry expert in insurance, statutory accident benefits, life care planning, and rehabilitation. My own business partner, Lynn Parker, is an insurance claims management professional with added expertise in SABs, statutory accident benefits, and a certified life care planner. All mediators work hand in hand with the parties to tailor the process and speed up the identification and exchange of party interests to help the parties arrive at options for settlement. The second tool I want to simply touch on is early neutral evaluation. Early neutral evaluation is a process pioneered by the California courts with the goal of reducing litigation costs. Despite the widespread use of court-annexed early neutral evaluation in the United States and other countries, its use in Canada has been very limited so far, other than in family law cases. ENE is a mechanism best used at an early stage of litigation or even prior to litigation. Its main advantage includes opening up direct channels of communication at an early stage, which allows early identification of core legal issues, narrowing of points and issues, and narrowing of discovery plans. This avoids unnecessary costs of oral and documentary discovery and formal proof of admitted facts. The neutral evaluator receives written statements from the parties along with relevant documents and critical oral discovery or witness statements. He or she then meets with the parties in a without prejudice joint session and subsequently provides them with a short written evaluation, which assesses the relative strengths and weaknesses of the party's position. The evaluation may also include a settlement range. E&E lends itself well to cases where there are complicated or unusual mixed questions of law and fact, difficult evidentiary issues, difficult to prove damages, and where the case will turn on expert evidence. If you'd like to know more, I've written about co-mediation and early neutral evaluation on the cadre, that's short for capital ADR experts website. That's the website of my dispute resolution firm. Visit us at the-cadre.ca, where you can also sign up for our quarterly newsletter or drop me a note, and I'd be very happy to speak with you. Thank you.